All right. Well, welcome once again. Hello, everyone, and welcome to this live session here, the Employment Law Live Session. My name is Lior Samfiru. Many of you know me by now. I've been doing this regularly, and they call me the employment lawyer. I've said this before because I practice employment law. In fact, I'm the head of the employment law practice at Samfiru Tumarkin LLP. We're a national firm with offices in Toronto, Ottawa, Vancouver, and Calgary, and operate in all those provinces. So why am I here and why are you watching me? Well, I'm here to talk about employment law. I'm here to talk about workplace rights. I'm here to tell you what you need to know about your rights when it comes to your job security, to your entitlements if you're being mistreated at work, if you lost your job, if you're worried about losing your job, if you're on a layoff, if your job has changed, if you're not getting paid properly, if your boss is not treating you properly. Man, oh man, I think you get the idea. There's so many things we talk about on these segments. There's so many questions you can ask. So remember, we are live right now. I'm live, you're live, and the reason I'm live is I want to take your questions. So if you're watching right now, watching is great, but you can do the other thing, which is ask your question. Type it up, press the enter button, I'll see the question and I'll answer it. And then you can walk away with the knowledge and the information that you need to know about your rights. Employment laws are quite good throughout Canada. They're extensive, they protect you, they give you a lot of options, but you need to know what those rights are. Having rights is no good if you don't know what the rights are. Well, that's why we do these segments. That's why we are live here answering your questions. So you can call or you can contact us right now, post a question, I will answer it. And of course, if you don't really want to ask your question live right now, if you want to have a private chat, a private discussion with me, that's perfect. That's very easy to do. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see my website there, my firm's website. You see the address right here. And you'll see my contact information there, my phone number, my email address, my fax number. There's forms you can fill out online right there if you want. And by doing that, we can connect off air. So you have two options right now, live, ask your question. You can do that right now, easy to do. I'm here for a while answering questions. Or option number two, as I've said, you can reach out to me privately through employmentlawyer.ca. But as I said, I am live right now. And in between your questions, I wanted to talk about a few employment law issues or questions that come up now during COVID-19. And I've talked about this before, probably on last week's segments, but I get questions about this all the time, daily, multiple times a day. So I think it bears repeating. And that has to do with vaccines. Okay, let's talk a bit about vaccines while we're waiting for your questions. Can your employer make you get a vaccine? Should you refuse? Can you be let go? Can you be put on a layoff because you don't get vaccinated? So let's talk about that. For most people, the general rule is your employer cannot force you to get vaccinated. They cannot threaten you. They cannot refuse to hire you. They can't send you off work if you decide not to be vaccinated. Okay, there's various laws and rights that protect you, human rights laws, privacy laws, and so you can't be put in that situation. An employer in most cases cannot do that. There's probably some exceptions, hospital, long-term care. By the way, in Ontario, the government has said that in long-term care, employees have to be vaccinated, but that's up to the government. If the government legislates that people have to be vaccinated in specific industries, then the employer and the employee have to follow that. Until that happens, your employer cannot force you. I've spoken with a number of employees that found themselves in that situation. The employer said, be vaccinated or else. That's not legal. Your employer can't and should not do that. If you find yourself in that situation, you've been given an ultimatum, let's have a chat. Contact me, let's have that discussion. Ultimately, your employer cannot make the decision that you have to be vaccinated and threaten you. So that's a very important question. It's a question I've been getting lots and lots over the past number of weeks. So hopefully you now know. But if you have your own question about vaccines, about anything to do with your job, ask away. Don't be bashful. The reason why we're both here right now is so that I can answer your questions. So Ari, I see you there. Ask your question if you want that answered. Now, the corollary to what I said in terms of vaccines is what obligations do employers have to keep employees safe? And remember, the employer has a very important legal obligation to keep employees safe. When it comes to COVID-19, that means the employer has to take all available measures and follow all directions by the government in terms of social distancing, in terms of closing the operation, limiting people, wearing masks. The government has guidelines for all industries, and your employer has to follow those. If your employer doesn't follow those, that's illegal. That could give you a tremendous amount of rights, and you can force your employer to follow that. You should not work unless your employer is following health guidelines, especially during COVID-19. You have a right to refuse work. If you're ever in that situation, you know what to do. You reach out to me, and I'll be able to help you. But right now, for now, let's start answering some questions. I'm going to start answering some questions as they come. Call or write it in your question right now. I'll see it, I'll answer it, and hopefully you'll feel better once you have the answer. So first question comes from Ramez on Facebook. Okay, it says, how much does it cost to use the service of an employment lawyer in the case of a severance pay? Is it more cost efficient to negotiate with the employer directly? So let's start with the second issue. The reason why we have 40 almost lawyers in 3 provinces is because you cannot negotiate properly with your employer directly. The reality is, if you're owed 20-month severance, the chances of you being able to get anywhere near that directly is slim to none. The chances of that are almost inconceivable. So that's just not an effective way. It's not going to happen. It's not possible. Your employer, the moment they're negotiating with you, they're going to see that as to their advantage. They're going to assume you don't know. They're going to assume that they have the leverage. So not a good idea. In terms of costs, most of our cases are on a contingency basis. Whatever you've been offered, any improvement that we get over that, we negotiate a percentage. We also get the company to cover most of those legal fees. So you should never, ever be worried, Ramez, about legal costs, okay? Never be worried about that. The problem also with negotiating with the company is you can actually hurt your negotiating position. If you're owed 20 months and you say, I'll accept 14, well, guess what? It's going to be very difficult for me to then get you 20 months because you've already told them you'll accept 14 months. Don't do that. Don't compromise your rights. Don't compromise your negotiating position. If you lost your job, let's have a chat. Let's figure out how much you're owed and talk about what we can do to get that for you quickly. So Ramez, very important question. I get that asked a lot. So thank you for that. Reach out to me if you have a severance issue. If someone you know has a severance issue, happy to talk to them. But right now, ask your questions, guys. Let's make sure we answer as many as possible. Next question on YouTube from Ari. I was wondering if my supervisor can deny me voluntary overtime. He basically said that no overtime will be afforded to me only because I replied to an email in all caps. So I think what you mean is, can your employer decide not to schedule you for overtime? Generally speaking, an employer can decide who to schedule and who not to schedule. That said, if you can show that you regularly work a certain amount of overtime, so let's say you can show you regularly work 20 hours, I don't know, of overtime a month, and now all of a sudden your employer says that's not happening anymore, well, that's a change to the terms of employment, and that can result in a constructive dismissal. All right. So, but if your overtime is kind of all over the place, sometimes you get it, sometimes you don't. Now your employer doesn't want to give it to you. That's not going to be a real issue from a legal standpoint. The question is your employer changing the terms of employment? If you regularly have overtime, now they took that away. No, it's essentially giving you a pay cut, which your employer is not allowed to do. So Ari, if that is your situation, I want you to reach out to me. And the best way to reach out to me, just go right now to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see my email address, my phone number, all the contact information is there. Here's the address right here, employmentlawyer.ca. Ari will connect and I'll help you. Thank you for that question. Excellent question. Next question, another one from YouTube from Sukena. And again, if I mispronounce the name, I do apologize. It's not done on purpose. Sukena asks, what if an employer is refusing to give termination letter as well as pay stubs after you take leave of absence and they terminate? Well, it doesn't matter what they do. It matters what we do about it. So you don't have to stress out over it. You call me and I'll deal with it. They have to pay severance. The other issue is if they let you go after you took a leave of absence, that could be a human rights violation, depending on why you took a leave of absence. The employer also has to provide a pay stub. So the question is, why are they doing that? The question is, what do we do about it? So Sukaina, contact me. I'll help you get that. Severance could be as much as 24 months pay. There could be human rights damages here, again, depending on why you took that leave of absence. So let's have a chat off after that. Employmentlawyer.ca, Sukaina, reach out to me. Let's have a private chat. Next question comes from Anna Lynn. My husband works for a mining company in Alberta. He was laid off with vacation pay when the mine shut down in February. He has not been recalled since. The mine has filed for insolvency, but is still operating. Everyone has been recalled except the 4 Filipinos. What are his rights? So the big issue here is that of insolvency. If in fact they're under insolvency protection, at this point you can't do anything about it. And that's the concern, that essentially the company has this protection around it. Otherwise, this would be a human rights violation. Otherwise, this would be a wrongful dismissal. You name it, it's illegal. You can't discriminate. But if they now have this insolvency, unless they come out of it, in which case, guess what? You have all kinds of rights. But Annalyn, until they come out of that insolvency, it's a form of bankruptcy proceedings. Right now, they're not even managing their own operations. They have a trustee that's managing their operations. If they come out of it and continue operating, that's when it's time to do something about it. So Annalyn, you and your husband, keep an eye on what's happening there. I'm sure he has colleagues there that can update him as what's happening. If they're out of this insolvency, let's talk about it immediately without waiting. All right? So employmentlawyer.ca to have that discussion, Annalyn, with you or your husband. Happy to chat. Just go to employmentlawyer.ca. But right now, for now, we are still live. You still have plenty of time to ask your questions, so don't hesitate. We are live. I'm live. I want to answer as many questions as possible. We've gotten some great questions so far, so let's make sure that we answer as many as possible. In between your questions, I was talking about some of your rights during COVID-19. Next question I'll tack on is, can an employee be temporarily laid off because of COVID-19? So generally speaking, the answer is no. You cannot be laid off temporarily, even if it's because of COVID-19, unless your business is completely shut down, okay? Unless your business can't operate because they have to shut down. The government told them to shut down. Even if they're operating at reduced capacity or business is slow because of COVID-19, they don't actually have a right to lay you off temporarily. If they do, you, the employee, have a right to treat that as a termination of your employment. So remember, no, you cannot be put on a layoff. People ask me often, well, how long can my employer keep me on a layoff? I've already been on a layoff for months. Well, no, they don't have a right to even put you on a layoff. It's not a question of how long can they keep you. It's a question of, can they even put you on a layoff to begin with? And the answer in most cases is no, they don't have a right to do that, okay? You have the right to accept a layoff if you want and sit and wait to see what happens, but you don't have to. You can choose to get your severance and move on. And why is severance important? Because it could be as much as 24 months pay. That's 2 years pay. So if your salary is $50,000 a year, your severance could be, depending on how long you've worked there, could be $100,000, okay? We're not talking about, well, $1,000, $2,000. It could be a significant amount. So if you've been laid off temporarily, you have that option. Now, for those in Ontario, keep in mind that there's this July 3rd deadline. That deadline is not really relevant because you have a right to disregard it. You can get severance now. You don't have to wait till July the 3rd. But if you want to wait till July the 3rd and see what happens, if come July the 3rd, you're not back to the same job at the same pay, you have to reach out to me. Not a week after, not after you check other things. You have to contact me right away, as soon as possible, so we can get severance. It's illegal, okay? You can't be kept on this layoff. If you want to say enough is enough, if you want to pursue your rights, if you want to get the severance that you're owed, then by all means, let's talk about that. And you know how to do it, employmentlawyer.ca. Right now, ask your questions, guys. A lot of people watching, so ask your questions. Next question from Gospel Intel. I'm going to a mediation. Any advice? My best advice, talk to your lawyer. Your lawyer should be able to guide you as to the mediation. If you don't have a lawyer, get one. You will not be successful. You will not be able to do a good job without a lawyer. That's the best advice. It's like saying, I'm about to give surgery on myself. Give me some advice. Best advice is don't do surgery on yourself. Get a surgeon to do it. Same thing with the mediation. Don't go to a legal proceeding without a lawyer. You have to have a lawyer. It's not even debatable. Otherwise, you're at a huge disadvantage. You could be offered X and you will never know if it's a good offer or if it's not a good offer. How would you know? So the company offers you $5,000. Maybe it's an amazing offer. Maybe it's the worst offer ever. You need a lawyer. Do not go to mediation. Do not get involved in any legal proceeding without a lawyer. Full stop. Okay? Always. If you want a lawyer, let's talk about it, and I'll be more than happy to help you. Employmentlawyer.ca. Next question from Razor Sharp on YouTube. Should a severance package include any non-monetary benefits that you receive from your job if it otherwise costs you money? So very important question, Razor Sharp. So your severance should include everything you would have received had you continued working. So if you want to know if something would have been included, let's say you're owed 12 months severance. And if you want to know if something should be included, you simply ask yourself, would I have received this had I worked for 12 months? If the answer is yes, I would have, then it has to be included as part of your severance. So for example, we're talking, of course, salary, but also bonuses, benefits, commission, car allowance, phone allowance, stock options, you name it, they all have to be included. Even things like gym memberships, okay? All those perks that you have as an employee that you would have had if you continued working have to be included as part of your severance. So it's not just your salary. And sometimes these other elements can add up quite a lot. They could become very valuable. So that's why, again, this is reason 2045, why you have to get some advice if you lost your job, because we're not just trying to determine how many months of severance you're owed. We also want to make sure that everything that should be included in that is included in it. All right? Company's not going to forget about salary, but what about all the other components of your compensation? Chances are they're not included, which means we have to get them included. All right? Hopefully that answers the question, Razor Sharp. If you have a follow-up question, let's talk about that. I'll be able to help you. But for now, again, ask your questions. And you know, we were talking about severance. So let me give you the address or the coordinates for another tool that you have to have in your back pocket, quite literally. And that is pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. That's like having me. That's like having an employment lawyer with you at all times. When you go to pocketemploymentlawyer.ca, we have a lot of interactive tools there. For example, we have our severance calculator tool. If you want to know now, this very second, how much severance you are owed, just go to pocketemploymentlawyer.ca, answer 3 questions, and you'll find out if you're owed 6 months severance or 24 months severance or anything in between. Free, anonymous, easy to use. There's many other interactive tools. You can find out if the company had a right to let you go at all. You can find out if your matter is considered harassment or discrimination. You can find out if you're an employee or an independent contractor. Many people are misclassified, and much, much more. So pocketemploymentlawyer.ca, very important tool. For those joining us right now, again, welcome. My name is Lior Samfiru. I'm the employment lawyer, and I'm here to answer your question. I'm going to continue answering questions right now, but you got time. Answer or ask the questions. Give me a chance to answer them. We are live, so take advantage. Next question for Katie. Is a company at fault if there is a termination issue and they offer you $10,000 payout or your job? Does the company acknowledge they are in the wrong with the $10,000 offer? So, I mean, ultimately, a company has to pay you amount of compensation if you lost your job. It's not because they did something wrong. It's because the law requires it. Now, the company always is going to want you to sign something in return because they want to know that once they've paid you, you're not going to change your mind. You're not going to come back for more. So the real question is not about is it fault or not. The question is, are you owed $10,000 or maybe you're owed $200,000, right? The first step is to determine how much you're actually owed, Katie. So forget about what the company's offered. That's irrelevant. You need to determine what the company should be paying, not what they want to pay. That's why you go to pocketemploymentlawyer.ca. You can go there right now, Katie, pocketemploymentlawyer.ca. Use our severance calculator tool and find out how much you're owed. I bet you anything it's a lot more than $10,000. I don't know anything about your matter, but chances are, because that's what happens in over 90% of cases, that you're owed a lot more than that $10,000. So that's the real question, not what do they mean by that. The question is how much you're actually owed. All right, Katie, so hopefully that helps. Any follow-up questions? I'm still here. Ask. Ramez asks, is it on iOS or Android? So it's anywhere. If you have a web browser, you can reach pocketemploymentlawyer.ca. Okay. That's all you need. Doesn't matter what phone or what computer you're using. Thank you for that. Katie has a follow-up question. Severance offer for 11 years. Well, Katie, I don't know about your job or your age, but you're probably owed a year's pay, 12 months pay. So unless you only earn $10,000 a year, in which case that's 12 months pay, you're owed a lot more than that. So that is the real question. You probably owed about a year's pay, Katie, 1 year, 12 months. Tell me how much your salary is. I'm curious. Let's talk. Next question from Gospel Intel. He says, can you talk about workplace retaliation? Because it happened to me. I reported sexual harassment and racism, and I got threatened by the employer. Well, that's illegal. We call that a reprisal. You cannot be threatened, fired, mistreated, or anything happened to you if you report harassment. You have the right to report harassment, and an employer that does anything if you do is committing an illegal act. It's illegal. You can't do that. It's a violation of at least 2, maybe 3 statutes, not something that's possible. If you can show Gospel Intel that that's what your employer did, man, oh man, there's going to be significant repercussions, okay? You should always feel free to report harassment. You should always feel free to report any discrimination. You have the right and I would say the obligation to do that. If you're mistreated, let's get off internet right now and let's contact me. Reach out to me, employmentlawyer.ca. Let's have a private chat. Katie says that she makes $75,000 a year. Well, Katie, 12 months is $75,000. You were offered $10,000. Do you see what I mean? So the question is not so much, tell me what this $10,000 mean. The question is, forget about $10,000. Who cares about $10,000? You're owed $75,000. So now that we know this, Katie, next step is you call me. All right? Go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see my phone number, my email address there. Call me today. Let's have that chat. Okay, time is not necessarily your best friend here for various reasons that I can explain later. So if you're owed $75,000, for you to accept $10,000 would be just wrong. So let's have a chat. Thank you very much for that, Katie. Next question is from Eileen. My husband has been working as a building superintendent for a number of years. He gets paid for 86.7 hours twice a month. The problem is that he is on call every second week. This includes weekends, statutory holidays, and holidays. He does not get paid any additional pay, as in overtime or paid for holidays, etc. Should he not be paid for the extra hours that he works? He does not have a written contract, as the company refused to give anyone a contract. Yes, he should be absolutely paid. And for that, Eileen, your husband should go to the Ministry of Labor. Now, the only way to resolve this is to do something about it, and that's never a comfortable thing when you still work there, but he's being taken advantage of, okay? He's being completely treated in an illegal way. So I can get involved, or the Ministry of Labor can get involved in whatever province you're in. Either way, he has rights. He'd be owed back pay. The company could even potentially be fined for breaching the law and not paying them what they're supposed to. That's not possible. He has to get paid statutory holiday pay. He has to get paid for time that he's effectively working. So no, the company can avoid that. Whether he has a written contract or not, that's fine. I don't like written contracts for employees. For an employee, by the way, it's better not to have a written contract. For an employer, it's good to have a written contract, not for an employee. So we're fine there, okay? But what he needs to do is go to the Ministry of Labor. He can contact me as well if he wants, of course, because, again, that's not legal and he shouldn't just accept it. So, Eileen, hopefully that makes sense. We have some more time, guys. Again, I'm Lior Samfiru. This is the employment law session here. So ask some questions if you're watching. We're live. I want to answer as many questions as possible in the remaining time. And in that regard, I'm going to move over to a question from Ruby. I work 2 days and take 3 days emergency leave. My company wants to withhold my weekly bonuses and affect my year-end bonus. Can they do this? No, they can't. Absolutely not. So that would result in what we call a constructive dismissal, potentially. If they're withholding payment or they're not paying you money that they owe you, or if they've changed the terms of employment. And by the way, depending on why you're only working 2 days, that in itself could be illegal. Reducing it from 5 days to 2 days may be illegal unless you ask for that to happen. But if the company says, wait, moving forward, you're only working 2 days, that itself is illegal. I know that there's this emergency leave. Despite that, it's still illegal, Ruby. Okay, so there's a lot of things to talk about. Let's have a chat privately, again, so that we can get into it more. I can tell you whether things are illegal or not here. What I can't do here is actually do something for you. I can't resolve the issue. To resolve the issue, you have to contact me through employmentlawyer.ca. And I see, Ruby, you say that you asked for the leave, and that's fine. But there's still the issue if they're not paying what they're supposed to, or if they've changed terms of employment. Well, that's a different situation altogether. We need to have a chat about that. So please reach out to me, and I'd be more than happy to speak. Hopefully I'm caught up. We got a few more last minutes here. So let's make sure that we answer as many questions as possible. Now, I touched on severance earlier in the show. So I get asked often, well, now that there's this pandemic, does the pandemic impact my severance? And the answer is yes, it does. It increases the severance, right? The reason why it increases the severance is because of the pandemic, it's probably going to be more difficult to find another job, right? There's more people looking for jobs. There's less companies hiring right now. So if it's going to take you longer to find another job, that's going to increase the amount of severance that you're owed. So it's easy to think, well, because of the pandemic, maybe the company doesn't have to pay me as much severance. Not only do they have to pay you severance, they have to pay you arguably even more severance than they would have had to before the pandemic. So do we need even more reasons to reach out to me if you lost your job? Hopefully that clarifies it. Again, employmentlawyer.ca to connect with me off air. Okay, so please take advantage. You see the address, employmentlawyer.ca. Next question. You got last couple minutes. Ask questions. From Kido Chokru. Oh, I probably mispronounced this. I do apologize. I don't mean any insult. Kido Chokru says, my employer changed my evaluation from positive to negative and fired me for misconduct after I have reported a patient's abuse. Can I sue for falsification of documents? No, you can sue for wrongful dismissal if you're not part of a union, okay? If you're part of a union, the only thing you can do is file a grievance with respect to your termination. If you are not unionized, then it's not about the documents being falsified. It's about the fact that unless you did something terrible, you can't be fired for cause and you're owed severance. Keep in mind that the only way that you can do that is if you're not part of a union. And I should make mention that everything we talk about on these segments generally only applies to non-union employees, to non-union. If you are part of a union, the only one that's allowed to help you is the union, and your rights are going to be very different, especially when it comes to severance. Unionized employees don't really get severance. So union is your best, really, it's your only recourse if you have a legal issue. So hopefully that answers the question. If you're not part of a union, Cody Chico, I want you to reach out to me as soon as possible. Again, employmentlawyer.ca. Ruby, let's have a chat privately about the situation. They say that you're a part-time employee. So yeah, definitely time to contact me and we'll have that private chat. So, okay, Kiduchika, you're not part of a union. So good. So It's not about the documents, it's about the compensation that you're owed. And again, it could be as much as 2 years' pay. So you have to reach out to me. Again, I'll give you the address one last time. We're about to end this session. Go to employmentlawyer.ca. Again, employmentlawyer.ca. That's the time that we have for this week. Tremendous questions like we get every week. I'm Lior Samfiru. I'm the employment lawyer. I really appreciate you joining us on this session. I'll be back next week, next Wednesday. Don't wait until next Wednesday. I've given you the contact information a number of times. Reach out to me. I see there's more questions coming. Reach out to me privately. Go to employmentlawyer.ca. Let's have that chat. Don't wait a week. Don't internalize these things and hope that they're going to resolve themselves. They're not. So let's have that chat at any time. I'm not going anywhere. I'm getting back to work. So thank you again for joining us today. Have a great rest of your day, great rest of your week. We'll talk to you soon.